Good afternoon and welcome to the Investor Responsibility Research Center Institute webinar on our latest research report, The Public Fiduciary, Emerging Themes in Canadian Fiduciary Law for Pension Trustees. Today we'll do brief introductions, an overview of the research and its findings, provide the IRRC Institute's perspective on the research, and then take your questions. Our speakers today are Edward Waitzer, partner with Stikeman Elliott LLP. Ed is in the Toronto office of Stikeman Elliott. His law practice focuses on complex business transactions, acquisitions, restructurings, as well as public policy and governance issues. He is the co-author of the report we'll be reviewing today. Also on the call with us today is Douglas Sorrow. He's a student at the Osgoode Hall Law School, and he is a co-author of the study along with Edward. And closing up will be John Lekumnik, Executive Director of the Investor Responsibility Research Center Institute, and he'll provide insight on the Institute's perspective on this research and why it's important. Just a few words about the IRRC Institute if you're not familiar with the organization. It's a nonprofit located in New York City, headquartered there, and it was established in 2005. Essentially what the organization does is it funds and disseminates research at the intersection of corporate responsibility and the informational needs of investors. All of the Institute's research is available at its website, irrcinstitute.org, at no charge. Here we have a listing of the broad range of research that is available on the website. You'll see it covers a wide variety of issues. This is a listing of just a few selected recent reports, everything from sustainable reporting to executive compensation to environmental, social, and governance issues, to hot topics such as hydraulic fracturing and discovering shale gas. So again, you can download all of this along with supporting materials on the website at no charge. The Institute also has launched an annual award. This is our second year doing it. It was launched in 2012, and essentially what it does is it encourages thought leadership that integrates an analysis between private sector behavior with investment theory. So each year, the Institute provides one academic and one practitioner paper award, and each paper receives a $10,000 award. Our winners this year for the academic award were a team led by Professor Lucian Bebchuk at Harvard, and it relates to governance issues. And then the second award is the subject of our webinar today, which you know, it's the Practitioner Award. And I will hand it over now to Ed Waitzer to provide an overview of that research. Ed?
Great, sorry, I was on mute. Hi there.
We can hear you now, great.
Can everyone hear?
Yes, we can hear.
So shall I just spend a few minutes walking through the paper, and then hopefully we can engage in a discussion about it. Doug is here with me, so he may join in at any point. Essentially, the paper is actually the third in I guess now a trilogy of papers exploring the question of how we can both encourage and equip decision makers to take a longer term and more systemic view in a world where the incentives for myopic or short-term leadership tend to be overwhelming. And our focus in the three articles, Doug was co-author on the third, has been on pension fund trustees, specifically trustees of public pension funds, because of a couple of things. One is the size of the assets under their management, but more importantly, the nature of their legal obligations, which are quite unique and specific, and the fact that in many ways they sit on top of the governance chain, if you will. That is, if they were inclined to act collectively, they have and can exert tremendous influence on the system. The specific article is a legal article. We're not going to spend a lot of time dwelling on sort of the legal learnings per se. other than our way into this article was a focus on the Supreme Court of Canada, which is unique amongst higher courts in the Western world. And for purpose of our analysis, we were looking at the UK, Australia, the United States, Canada, so common law jurisdictions, in that unlike other Supreme Courts which have tended to try to avoid rigorous analysis of the nature and consequences of fiduciary relationships, the Supreme Court of Canada has embraced it. And our thesis on why they've embraced it has to do with the relationship between the Crown, that is the federal government in Canada, and Aboriginal peoples, First Nations. And there is a wealth of law at the Supreme Court level that has explored and defined that relationship. And coming out of that law, we see principles that in turn have informed a number of other Supreme Court decisions in the financial sector and elsewhere as to the nature of fiduciary relationships. So that's our entry point. And I don't propose to spend a whole bunch of time on that, other than that's sort of the lens through which the court has thought about fiduciary relationships. As they articulate the nature and consequences, you see their thinking focusing on essentially the fact that in today's society, we increasingly rely on the services and expertise of others, of strangers. And this rise in what can be characterized as fiduciary society becomes a bit of a classic non-zero sum game, where everyone benefits as long as the system is working well, but if trust is eroded, the game fails and everyone loses. And in many ways, that's the underpinning of the court's approach to these issues. Kelly, if you want to flip the slide over. Stemming from that approach, the court in a bunch of decisions, many of which we've described in the article, and many of which relate to financial services or corporate law, have been quite vocal about sort of the growing significance of fiduciary services, the fact that those services are underpinned by trust and loyalty, that the nature of fiduciary obligations is inherently dynamic, and in a sense, the court has as much as said, if not directly, indirectly, that social norms, in effect, are leading indicators of where the law is going to go. And we see that most recently and most explicitly actually in a corporate law case, which was one of the few cases that our court has dealt with in the corporate law context. It was a change of control transaction for BCE, the telephone company, dominant telephone company in Canada. And it was a classic case of bondholders arguing that in an auction, shareholders were being favored to their prejudice. And what the court, while upholding the determination of the directors of BCE to maximize value for shareholders, went through a very careful analysis of how the board had considered the interests of other stakeholders, and was quite explicit in saying that the best interest of the corporation doesn't necessarily mean the best interest of any particular set of stakeholders. It is highly context specific, and that the court expects boards to carefully consider the interests and reasonable expectations of all stakeholders, and if they do so, and only if they do so, will the court defer to their judgment. So a very different articulation than you would find, for instance, under Delaware law today. But it's illustrative of how this almost tautological concept of reasonable expectations in effect informs and defines the law. And faced with that framework, you can see both how and why the Supreme Court is trying to encourage fiduciaries to err on the side of caution. Basically saying, in a roundabout way, articulating a precautionary principle and saying, look at, we expect fiduciaries to respond to the interests of beneficiaries. Kelly, if you can flip to the next slide.
Here we go.
Thank you. Perfect. So that's sort of the legal analysis. We then try to apply that to traditional trustee duties in the context of public pension plans. And again, by way of context, Canada tends to punch above its weight in this sector because we have a relatively small number of relatively large public pension plans, and the governance, there's been a lot of attention to governance structure. So, on a world scale, governance of the major public pension plans in Canada rank fairly high. So all of these plans are actively thinking about the kinds of issues we address in this article. But when you think about the logic of the Supreme Court of Canada in the context of the duty of care, you can see how one might pause and reflect about sort of how the duty of care, that is to act with prudence, might evolve, and how the current conception, or the conception certainly leading into the so-called financial crisis, is certainly contestable. And we've listed a couple of the elements of that here. That the fact that the current conceptualization of the duty of care has led trustees to focus on not underperforming market benchmarks, as opposed to focusing on improving the performance of the assets that they're investing in, mitigating risks, addressing externalities both on a specific and systemic basis. Again, if your focus is on not underperforming, by definition, you are preoccupied with minimizing costs, because costs ultimately lead to underperformance in a passively managed environment. So there are disincentives for stewardship and collaboration, which we argue are necessary in order to address systemic issues. The focus of trustees has been on compliance and mitigating liability rather than stewardship. One of the ways to mitigate liability has been to delegate to agents, and we've spawned, whether we're talking about, and this is a governance problem generally, it's as true of corporate governance as it is with respect to pension fund trustees, but a response to personal liability has been reliance on experts, which has spawned cottage industries of consultants of all sorts, compensation, investment consultants, financial consultants. A curious aspect of this delegation phenomena is you can delegate and thereby set up a defense, but the delegate doesn't necessarily assume the fiduciary responsibility. So inherent in the delegation model is an abrogation of the fiduciary principles and duties that kind of are fundamental to the law. And that in turn creates a whole new series of conflicts of interest when the interests and incentives on the delegates aren't aligned legally with those of the trustees. Kelly, if we can turn to the next slide. I mentioned at the outset that one of the reasons for focusing on pension fund trustees is that their duties are clearer and much more unambiguous in some ways than the duties of directors. So when I talked about the BCE case, which was a case about the duties of corporate directors and ultimately what the legal concept of the best interests of the corporation means, there's always going to be some ambiguity in that concept. In contrast, the duties of trustees are direct. They aren't to a legal construct. The duties are owed to beneficiaries. And we would argue the duties are owed to beneficiaries extending out over time when you're talking about public pension fund trustees, so A, the duties aren't to a plan. The duties flow through directly to beneficiaries of the plan, and B, implicit in the duties of trustees is a duty of impartiality, that is, being even-handed as between current and future beneficiaries, and that's just inherent in the nature of what a pension fund is all about. It's managing assets to provide for long-term income security and well-being. This concept of reasonable expectations is something that we kind of conclude the paper by trying to tease out a little bit, and we've pointed to, it's fine to talk about the duty of impartiality and the need to be even-handed. It begs the question, how do you do it? And in some ways begs an even more fundamental question about how do we think longer term? How do we mediate interests that at times are almost by definition going to be opposite? And we've thrown out in the article 4 tools that we think are part of the construct for meeting this duty and meeting what, at least at this point in time, should be reasonable expectations. One is respect for social norms. The second is giving beneficiaries a voice, which ties into a fiduciary obligation to consult with beneficiaries, and which we think implies a duty to inform, because there's not much point consulting if you're not giving beneficiaries adequate information to enable them to make provide intelligent input. There's an interesting subset issue in giving beneficiaries a voice, which is the issue of how do you give a voice to future beneficiaries, and we've begun to explore that in the paper, drawing on mechanisms elsewhere, ombudsperson concepts, proxies of one sort or another that have been established under trust law to meet similar challenges in other contexts. And then the last two, which we think are immediate, are sort of duties to both be strategic and to collaborate. That is, you can't deal with systemic issues. We can't deal with sort of externalities on a isolated basis, either isolated in the sense of one pension plan at a time or isolated in the sense of one issue at a time. It really requires rethinking what investing is all about. And as I suggested earlier, thinking of it in terms of being a means to ensure future well-being that requires a broader consideration of systemic effects. How can investments create better markets and a better society tomorrow rather than simply beating the markets today? So those are sort of the main points that we try to develop, and hopefully we'll continue to develop as we work along. Our goal here is creating a toolkit for trustees, and there have been a number of people who've been working in this area, and I think it's fair to say that most public pension plan trustees, we had a session up in Toronto hosted by the Rotman Institute for International Institute for Pension Management about a month ago, working on some of the recommendations that came out of the Generation Investment white paper. There was a very high degree of consensus on the underlying thesis. So the need to focus longer term, the need to look at systemic issues, an acknowledgement of the duty of impartiality, an acknowledgement of the need to rethink duty of loyalty and duty of care. The discussion becomes more problematic and requires a lot more thought when we then say, okay, how do we move from theory to practice? How do trustees discharge these evolving duties? And conversely, how are they going to defend themselves if challenged on the basis of the kinds of obligations that we've articulated in this article? And we hope we've kind of made a couple of baby steps along the way in this article, and we'll continue to work on it.
Hi, it's John
Don?
Lemnick. Yes, thank you, Ed. It really is a wonderful paper. For those of you who haven't yet read it, it's available, obviously, free of charge on our website, ircinstitute.org. Just click on the resources page and you will find it. Unfortunately, the limitations of finite time webinars, I think, mean you can't get into all the depth and robustness of the paper. But Ed, Doug, thank you very much for writing it. Let me tell you, first off, my thanks to the judges on the paper competition. I do not vote on this, so I'm somewhat impartial in my comments here. For those of you who don't know, the judges are a mix of practitioners and academics. Bill Miller from Legg Mason, Colette Chilton, the CIO at Williams, Rob Arnott from Research Affiliates, Mark Anson, now at the Bass Family Fund, and Jim Hawley, a professor at St. Mary's. That said, I found it interesting. This entire area of fiduciary obligation really is a hot topic. This is the second year of our paper competition. The two academic papers couldn't be more different. Interestingly, both practitioner papers that the judges selected were on fiduciary obligation. And these are intelligent thoughts about fiduciary obligation. Ed mentioned the Lemming Standard. For those of you not familiar with that, too often the naive view of fiduciary obligation is do what someone else similarly situated, well-intentioned and informed will do. The problem with that, of course, is if you are a lemming, you go over the cliff with all the other lemmings. This paper says, no, that's not what you do. You actually have to think about systemic issues. Ed puts it, gets there through what he calls the duty of impartiality, what some people in the United States would call intergenerational equity, that future beneficiaries don't necessarily benefit from minor outperformance in the short term if what it does is not improve the overall performance of the system in the long term. So this is, I think, a very intelligent paper using time frame in a way that gets to what many people understand intuitively, but this does it on a citation by citation, logical manner. I think it will have a lot of resonance among people who are looking at these short-term, long-term, and fiduciary issues for the foreseeable future. Kelly, can you get the next slide? There are a couple of reasons for this, and Ed spoke about reasonable expectations, and social norms. There are two ways that fiduciary obligations change in the real world. I will tell you myself, having been a pension fund trustee, as a mutual fund trustee, as a corporate director, we are counseled by legal all the time as to what our fiduciary obligation is, but it's not static. First, and the most definitive way, is a legislative body can change the law. This has happened fairly often. It doesn't often get couched in fiduciary obligations, but since part of fiduciary obligation is you can't change the law, A, they can just change what fiduciary obligation is, or B, there's a famous case in England, for instance, where in the early 20th century, a charity wanted to pay women, and it was a charity for the betterment of women, wanted to pay women equal wages. The Charities Commission in the UK sued it, ruling that that was a squandering of charitable resources. Clearly, after change in law, they are allowed to, and in fact prevented from not paying equal wages. So your fiduciary obligations can change with changes either in law or changes directly to fiduciary obligation. But more commonly, things change as a result of case law. And case law reflects the prevailing context and environment. The Delaware Court of Chancery, the Delaware Supreme Court, the various U.S. courts and state courts around the country, as Ed reminded me the other day, change fiduciary law every day. Because it reflects the contextual environment, it reflects the evolution of thought. And this paper, and we hope that the IRC Institute's recognition of this paper can be a major contributor to that evolution. We hope that our recognition of it will get it read by the various law firms that practice in this area, the various courts around the country that and in Canada that practice in this area. With that, in fact, Ed, I'll even put, we're about to go to Q&A, and Kelly, you can tell people how to do the Q&A, but I'll even post the first question to Ed on it, which is, how applicable do you think your paper is to Delaware and U.S. law as well as Canadian law?
Great question. And John, I should have taken the opportunity on behalf of Doug and myself to express our appreciation to IRRC and you in particular for not so much surprise, which was unexpected, but kind of being there and doing the kind of work that you've been doing consistently, because it provides a forum and a platform for, I think, some groundbreaking work over an extended period of time. You know, courts in different jurisdictions go in slightly different directions. So, as I indicated in my opening remarks, our Supreme Court has gone in a slightly different direction than Delaware in terms of articulating the duties of directors and what the concept best interest of the corporation means under corporate law. But they tend all to get to the same result and in a sense merge over time. So even in the context of BCE, while a Delaware court would have reasoned somewhat differently, there's no question they would have gotten to the same result. And you can find much of the reasoning of our Supreme Court in reasoning of previous chancellors in Delaware. I'm thinking in particular of Bill Allen, but others as well, Leo Stride. So when you get to the reasoning of our court in terms of fiduciary obligations, which, as I said, is an area that other higher level courts have tended to avoid rather than embrace, I think the reasoning is highly compelling, and it's just a matter of time until it gets picked up elsewhere. And again, if you look out more broadly as to what's going on in the pension fund area and in the financial services sector globally, what you see most dramatically in response to the global financial crisis is at a whole variety of levels, courts and regulators and legislators in effect fiduciarizing, if I can use that word, the supply chain. And so what we describe in the context of trustees' obligations for public pension plans may, in a sense, simply be a microcosm of a much broader set of developments in the financial services supply chain globally. That was a bit of a more of an answer than you were looking for, but hopefully provocative.
Okay, thank you so much. I'll just take a moment to give quick instructions on how to ask questions. On your control panel, you should have a box, a pull down that says questions. There you can type in a question, I'll read it aloud, and John, Ed, or Doug can answer the question. You can also type in the question box, unmute my phone line, and I can open up your phone line and you can ask your question over the phone. Our first question is, are the slides available for download? And yes, they will be posted by tomorrow, along with a replay of this webinar. So that will be available tomorrow on www.irrcinstitute.org. And we'll also send out an email with a link to where you can obtain the slides as well as the replay. Our next question, this looks like it's for Ed. Should your paper be viewed as a moral argument?
People often confuse, and I'm not sure I'm going to be very articulate in my answer, but people often confuse many of the arguments advanced in our paper and by others who, for instance, historically have argued in favor of socially responsible investing as being a moral argument. I would say that it isn't. And the differentiation I would make is, for instance, the differentiation that Michael Jensen at Harvard makes when he defines integrity as not being something about morality or ethics, but rather about what is required for a system to work as it is intended. So a bicycle wheel has integrity when it has all its spokes, back in the days when bicycle wheels had spokes. There's nothing moral or ethical about kind of having the necessary spokes and having them at the right tension, but that's what's required for integrity when you're talking about a bicycle. And I guess my argument would be that what we put forward in this article has to do with integrity of the system as opposed to a moral case. Although one could make the moral case, that's not our ambition.
Thank you. Our next question, what are the broader implications for the financial services industry?
Well, I've kind of addressed that in my answer to John's question about whether the article has relevance beyond Canadian law. But if you you know, as John pointed out, common law systems tend to respond to specific fact situations. We've got a whole host of specific and egregious fact situations that came out of the financial crisis. In some jurisdictions, there have been legislative responses. And when you look at those legislative responses, think about, for example, jurisdictions like the UK, Australia, which have essentially banned commission-based compensation for retail financial advice. So they've severed the link between investment advice and sales-based compensation, and basically have tried to construct a regulatory framework in which advisors are unconflicted and are only allowed to offer advice on a transparent fee-for-service basis. Think of the current controversy around the propriety or not of Thomson Reuters pre-selling the consumer confidence index generated that they buy from the University of Michigan, where there doesn't seem to be any controversy around them having pre-sold it for $20,000 a month to get a 5-minute timing advantage, but there's a huge controversy around further pre-selling it for an undisclosed amount to high-frequency traders who were getting an additional 2-second advantage, plus or minus 500 milliseconds. Sufficient controversy that the U.S. That the New York Attorney General has kind of shut it down for now. And if there's something wrong with that, is there something wrong with stock exchanges charging rent to co-locate servers in order to get a millisecond trading advantage? You can look all the way through the financial services supply chain and see examples playing out in real time right now, where that are ultimately rooted in a failure of trust and confidence, and are playing out in one way or another as an expression of sort of public fiduciary responsibility. So I actually do think it has broader application.
Okay, our next question, thanks very much. This is for you again, Ed. Does the fiduciary relationship recognize human rights, for example, the right to food? Does the benefit need to remain financial, investment to increase availability and access? Do you need me to
Sorry, could you say the last part of the question again?
The last part was, does the benefit need to remain financial, investment to increase availability and access? I guess availability and access to food, to human rights.
Well, I don't think the benefit, you know, I think sustainability, and I don't think there's any argument about this. Sustainability is much broader than financial. And if you talk to any successful corporate leader, they would agree with that proposition. And for that matter, if you kind of did a time and motion study of kind of what they dedicate themselves to, it would become immediately apparent that their concerns are much broader, and if indeed they're focused on the long-term sustainability and success of the enterprise, their concerns are much broader than financial concerns, although paying attention to a broader range of concerns, including human rights, contributes to sustainability, which ultimately should contribute to the financial success of the enterprise. Does that respond to the question?
I think so. And if it doesn't, we can follow up. Okay, we have another question that just came in. Passive investors create the opportunity for active investors to outperform since the passive investors stay at the table long after the active have cashed their chips in. As climate change becomes a reality and fossil fuel divestment becomes the active strategy, won't pension funds once again be holding the bag?
Sorry, will pension funds which?
Once again be holding the bag.
Boy, these are softball questions. That one isn't even a question. That's a rhetorical statement, and the answer, I think, is obviously yes, unless we become proactive about mitigating that risk, right? So, by definition, if climate change leads to any one of a number of predictable outcomes, including massive stranded assets, or for that matter, massive social unrest and disruption, there will be direct consequences both to the plans themselves, but more significantly to the beneficiaries. And the consequences will be both financial, in the case of stranded assets, and beyond financial, but also financial in the case of outcomes like massive social unrest. And again, the whole point of pension plans is to provide for retirement well-being. So trustees, I think, have to be thinking about these issues, and the only way they can meaningfully address an issue like climate change is collaboratively. They can't do it on their own any more than countries can do it on their own.
Great. Well, it looks like that.
I would just point out that there are, the questioner clearly has a point of view about what should be done. There are a lot of different ways to collaborate, from engagement through things like the Investor Network for Climate Risk to the Campaign for Divestment. So I would echo Ed's opinion that collaboration is necessary. I don't want silence to indicate that I am suggesting that any one goal of the collaboration is a preferred, necessary, or inevitable goal.
Great. Thanks, John, Ed, and Douglas, for participating, and thank all of you for being on the webinar today. Again, the information is available on our website. We'll send out a follow-up email tomorrow with the link to the replay, as well as the PowerPoint presentation you're seeing today. If you have any questions, please don't hesitate to give us a call or contact us. We have a slide here that's got all our contact information. www.ircinstitute.org and www.stikeman.com. And if anyone has any follow-up questions, please don't hesitate to contact us. Thanks again, and we hope everyone has a wonderful afternoon.